Adrian Love said to the judge, it's just patently not true, that Mr. Copeland did talk about the killing of Donovan Thomas. It's not on the transcript.
Wait, that's huge.
It is definitely still on the record in court, where y'all all heard that the state wanted an ex parte. People from the defense say other things on the record after that. In open court, y'all were notified that they wanted. It's not quite the salacious revelation that y'all made it out.
Day 104 of the Young Thug YSL RICO trial was interesting. The state and the defense go through Lil Woody's statements and decide what's going to be shown to the jury. Brian Steele then drops a bombshell at the end of this video. And the judge actually excludes some stuff that Glanville didn't do. Because maybe she's actually impartial and Glanville wasn't. But at the end, Brian Steele drops something, so hit subscribe, join channel membership. Here we go, boys. All right, here's Judge Whitaker's instruction for the jury.
Ladies and gentlemen, my name is Judge Whitaker. Judge Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say, and to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're gonna be like, oh my God, did he have a heart attack? Or, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. I am only interested in seeing that this case is tried fairly, based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you. Thoughts, objections?
I think that it's important not to say that don't worry about it, Judge Glanville was fine.
Okay, well, I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just
say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It just says he's been removed.
Well, he's no longer the judge presiding over the case.
She's trying to hide this shit, bro.
I would propose as a compromise, maybe just, I will be the presiding judge in this case moving forward. Then you're not to concern yourself with the change, which is already there.
The state and this new judge are trying to act like the jury don't already know that the judge was removed. I'm sure some of them know. They're trying to hide it from the jury. Why not just say he was removed? He was literally recused.
You are to disregard any comments made by Judge Glanville that may have been disparaging of any of the lawyers in this case.
Your Honor, would the court consider not instructing the jury as to anything?
If you want to think of some different language.
She doesn't like the word disparaging. Oh my God. Miss Love, dude. She's trying to hide all the bullshit under the rug away from the jury.
He did make comments disparaging of lawyers. That's not evidence. There's nothing wrong with me saying disregard that. So that's where I am right now. If you want to propose something else, then propose it.
I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about Judge Glanville has been removed.
Okay.
That's the appropriate objection from Steele. He wants the instructions to say that Glanville was removed.
We haven't changed our view on the things that we agreed with the state. I think we just need to go over the contested issues.
That works.
Okay, so now we're going over Woody interviews again. I'll try to make this as entertaining as possible. It's probably going to be extremely boring because we already did this before with Glanville, so...
that we don't have issue with moving forward. I don't know if we need to rehash everything, and we haven't had that conversation, so I don't know.
All right, y'all want to take a minute and have that conversation?
Yes.
I think I can answer that. I think anything that was litigated before needs to be litigated.
Oh my God, Max Schardt. I think he's only doing that because he wants to see if they can get a little bit better rulings from this new judge. He wants shit to be excluded.
Particular shooting of Lil Wayne's tour bus was a part of 2 events. So Lil Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil Wayne was one of Birdman's artists at the time, back in 2014 and prior to that.
So this is a big part that they want in about Lil Wayne's bus shooting. They want Woody to testify about that again, obviously. Demikian Gullington or Scarface told Woody about the Lil Wayne bus shooting, and Woody then, of course, snitched to the police about this, so they want to get these statements in.
Evidence has come in that members of YSL have made threats against individuals who we believe supported Lil Wayne during this ongoing dispute that they were having.
Is Birdman alleged to be in a rival gang, or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the 2 of them, in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. We believe that the gang, when Mr. Carter came to...
You would think this state would be better at explaining this if this is their whole conspiracy. They're terrible at explaining this. It's like word salad, dude.
Members of YSL just converged on the compound. They left their different I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that
Informing Woody about those activities, and then Woody snitched. So they're saying it's in furtherance of the conspiracy. The defense is saying it's not.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
no, we do not have any evidence.
Okay, so then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
Because it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual. It made the news.
Is the judge gonna flip? So this is why Max Schardt wanted to do this. The judge isn't convinced here, boys. And that's what I've been saying. There's not much evidence. There's just a lot of snitching.
Promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him? How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person that promotes the gang across. It made headline news.
But that's not the goal. They act like this shooting was, their goal was clout. That's literally not the goal.
Then apprising Mr. Copeland of it further the purposes of the gang.
Because it furthers his involvement, because he's still in the gang. He can still promote himself. He still promote himself as YSL, as being a part of the group that shot at the Lil Wayne's tour bus.
Do you have any evidence that he does that?
Promotes himself as YSL?
As, hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL, because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
No, we do not have any
The
evidence of him.
stutter. Did y'all hear that stutter?
Does he post or brag about YSL shooting up the bus?
No, we do not have any evidence of him.
And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Kenneth Copeland here on stand who can cross-examine. So it's not what he said verbatim to Detective Dennis. It's obviously what he stated to other co-defendants.
Right.
And so I just think Stafford is quite distinct from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy. But that's not the situation we have with Mr. Copeland, who's live and cross-examined.
Okay.
How you know Kenneth Copeland was not lying to the police? How does anyone know that? That motherfucker is a known liar.
I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you.
Your Honor, that wouldn't be correct anyway. That would be a confrontation clause violation. What the
Right.
attorney's talking about.
But that wasn't what I was using it for anyway, so.
Yikes, Brian Steele just flamed him.
After the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings. Right. One of those retaliatory shootings was on February 19, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Now in June, he is explaining to them why he did not turn in the gun. And so I want to give the court that context before we go into argument.
Okay, and so what's our issue with this portion of the transcript?
The state believes it should be played. We believe that this is intrinsic to that act from February 19th, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is. We don't think it's character. The fact that Shannon Stillwell had this gun, I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character, and if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19th.
Kind of is bad character for a convicted felon to have a gun and show the jury that, but...
To the extent that the shooting on February 19, 2015, where individuals shot at Kenneth Copeland, the story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby and he's with the mother's child. He shoots back. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I want to do that for the purposes of argument. But I don't know it's unclear to me what happened to Kenneth Copeland's gun, or the gun that Kenneth Copeland fired is not relevant. It has no probative value to this case. My client, the fact that he is in possession of a gun, he's not charged for that. It's not this is an overt act. it does place his character at issue. It's very similar to cases that he's charged with in his indictment. I believe he's charged with 2 different counts of possession of firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there. He's saying Shannon came and got the gun. My understanding of the sequence of events, Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point.
Yeah, I'm not sure if this is firsthand experience or not. It could be hearsay.
I don't believe it's hearsay. I believe I'm going back through the transcript that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leaves. So I don't think
that's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get you the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled. How about relevance?
So as far as
overruling hearsay?
relevant trial, we believe that the simple fact that he gets the gun from Shannon or it's Shannon's gun and he has to shoot back at the opposition gang shows, one, that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this, again, is a part of what the gang does. As a part of their enterprise conspiracy, they pass guns around, so we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in, Mr. Copeland got this gun from Shannon, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial effect.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10, 2015. But that's not what we do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine. Story, which really adds nothing to the state's case. The idea of, it's evidence of passing guns around. I mean, they're going to have direct evidence of Madari Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that.
Then it's kind of cumulative, and it's teetering that line that could be prejudicial.
Whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamel Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B objection also?
It's 404B, but it dovetails into 403 as well. It's just a prejudice of hearing.
It really can't be 404B if it's intrinsic, and you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland, they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
I find this evidence to be relevant and its probativity not substantially outweighed by the danger of unfair prejudice, so I'm going to permit that.
But that Shannon does anything Thug tells him to do. Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion of what he says in here, which is he does everything that Shannon tells him to do.
That Thug tells him to do.
That Thug tells him to do. We have charged Mr. Williams with a leadership charge, and so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang and now co-conspirator, member of the gang, is now telling law enforcement this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang.
Anything else, Mr. Schardt, on this?
No.
All right. I am going to permit this over the 401 and 403 objections. Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense.
So she's letting in what Woody said about Shannon?
After Donovan Thomas' murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together and they're driving on the highway somewhere near University Avenue and I-75. And the opposition gang shoots at their vehicle. Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but when I'm saying me and Shannon get in an argument plenty of times because these N-words done came, shot at us or did something. And what I believe you hear him say,
I never did
shoot back at him. And so he's talking about that particular
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay. And
Yeah.
so
we believe that's relevant. That furthers what he just said earlier in this interview about Shannon not liking the fact that he was not retaliating back against the individuals shooting at them. Your Honor, we do not believe that this is bad character, incidental character, Your Honor.
there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a victim felon.
Do you have evidence? I mean, not evidence. Do you have case law on that?
I don't, but
Maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just.
I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote-unquote hothead. I don't know what the relevance of him being upset that we didn't fire back or retaliate or do something. I don't understand. I'm not following how that's relevant.
Okay.
Not relevant to show he's a hothead. It's relevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And Shannon is one of the members who wants to retaliate. And I think that this is evidence of that.
All right. Well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out.
The judge letting pretty much a lot of stuff in, where Woody says a lot of stuff about other people in YSL.
My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
This man is known to carry guns.
he always carries guns. He always has one on. So, I mean, it would be like if someone's charged.
I mean, that definitely isn't a good look for the jury to hear. Woody said that Shannon always got guns on him and shit.
Copeland saying, hey, as far as I know him, and I know him, he carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law, and then we'll take it up after you've presented whatever you have and after lunch.
There was the conflict between Mr. Williams and Mr. Dwayne Carter. A number of other artists took sides, and we believe that the gang took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the gang. That, if he comes here, he gonna have to come see me, and he's threatening him. Right. Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them? And Kenneth says the Game was fixing to get his ass shot up, and would have if Thug would have and told Shannon to do it. Shannon told me out of his.
It says if Thug would have told Shannon
to do,
because then it says Thug told him no.
Right, and he says Shannon told me out of his mouth he was up. So it shows that Shannon's ready to do anything on behalf of YSL. That's why we believe.
I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that. It's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action.
Okay. Why is that evidentially inadmissible?
Because it's propensity.
To say this is somebody who stands ready to act.
Schardt keeps saying it's propensity, but the judge doesn't agree with that at all. She's letting other stuff.
It's bad character, and Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy. Argument, I think that just gets to bad character, and I think that's the essence of bad character and propensity. I respect it.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible evidentially.
This is all the theory of the state. It's also, the real theory is that there's this gang war between a alleged gang of YSL and a alleged gang of IF. These other people have nothing to do with that. I heard you ask, so this was involved in the, there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up. Yeah. And then the gang experts, quote unquote, come in and they say, well, this is what we said, and we found out. And I ask, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hilton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of emotion that I don't think you touched on yet. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act, and a long indictment. He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as Lil Wayne bus shooting. Okay. What the state did, though, was rather shocking. They had Detective Racy on the stand. Over objection, they played a recording from jail of the two people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Racy, who was under the directive of Ms. Hilton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hilton asks Detective Racy, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I can get to the site that vacated that guilty plea. That guilty plea was found to be coerced by the Honorable Judge Staley, and it's void and cannot be used.
So they used Demi Winfrey's guilty plea in court, even though it was overturned or whatever?
The state comes back after that and compensates, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later, and Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
You need the lawyers to tell you what went on, because you're catching up, and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with a gang war. This is dealing with an issue that, arguably, it's up to the jury. I understand that. Arguably, is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even. They're talking about real life, and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is, y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide.
I just want you to understand, it is not like this has been proven. You know, the game and that they've been shot at, it's just a theory. I don't want you to just buy into, like, oh, this is so important because it's already in evidence and the state needs to, you know, evidence and prejudicial.
All right, thank you.
Day in and day out, Brian Steele always just fighting for Young Thug's freedom right there, baby.
I can't Nilsson, he just heard something like that. He can't leave you. You know what I'm saying? He shot. I mean, I ain't here to play. I mean, I didn't want to go to jail. I mean,
Would he just be yapping and then I just don't want to go to jail? How can we trust anything he just said? And I can't even understand any of it.
All right, if y'all want me to figure out what got said, then I'm going to have that tape. I'm going to have to slow it down. I have no idea what he said. I mean, I know a lot of it, but the little part that y'all don't know either, I'd have to listen to it a couple of times.
You see Thug just laugh? Is there any evidence that the game got shot up? No. Like, this shit's so pointless.
What I hear them saying is the game fixing to get his ass shot up if Thug had told Shannon to do it.
the game did shut up and go to Shannon do it.
This man Woody is funny as shit, but he is a snitch. Like, straight up rat. Why are you telling the feds that, bro?
But I will re-listen to it. Okay, let's move on to the next one.
I recently filed while we were in court, a motion for a fair trial, seeking remedies. Oh, and I will.
So that's the motion I read at the beginning of this video.
And I'll email it over.
He said he needs to have it on the record himself. He said that what the state was saying is not. And I think that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate. Adrian Love said to the judge, it's just patently not true.
So he wants Melnick, Woody's lawyer, to come in and basically expose Miss Love that she's a liar. And I cannot wait for it on Monday.
Via emails, or description of the emails is untrue. And there's no way to say that's inadvertent because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her state. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
So he's also going to say Miss Hilton's a liar too?
Off. So it's not in the transcript. So Mr. Weaver's either not there or definitely not reporting it. That Mr. Copeland did talk about the killing of Donovan Thomas. It's not on the transcript.
Wait. That's huge. He's accusing the state and the judge of hiding Woody admitting to killing Donovan Thomas. That's insane. That's Brady and it's exculpatory to the defendants.
Wait, so that I understand what you mean. You are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Miss Bumpus talked privately, which obviously nobody recorded because at least the record reflects the court reporter and the court and whomever left the chamber so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left I don't know if it was you, Miss Hilton, or I think Miss Hilton, Miss Bumpus, and Mr. Copeland could talk together.
That's what I'm talking about. So it's not privileged.
Okay. All right.
But there was substantive conversation about the killing.
That'd be crazy.
And you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material. Impeachment. Okay. And therefore Brady. Okay.
Mr. Copeland did say on the record, I'm a liar. That's Brady. That's like the greatest Brady.
Well, you got that. So
I got that because
I know, but you have it now, so it's not Brady.
But it was Brady at one point. She keeps saying, well, you have it now, so it's not Brady anymore. He's trying to point out that there was prosecutorial misconduct and they hid shit.
My point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room and that was discussed. That's objectively true. So anyway,
Objectively true.
Everything I know, I'm told that it's not privileged that Miss Bumpus, Miss Hilton, Mr. Copeland spoke, and it's not in the transcript, and Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved.
Okay, well, that's new information for this court, so.
At some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte
Oh, I
communications.
know. That's a part of Mr.
Right.
Weinstein's motion for mistrial.
Her dude, I can already tell, she's going to say everything was proper in these ex parte meetings and the trial's going to go on.
About, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte. People from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out.
Oh, wait, hold on. The defense should have known about that, like realized that, but I'm sure they didn't know that they were going to be called outside agitators in it, did they? Because the subject matter is still pretty bad.
I think a fair, reasonable deduction would be that they were going back there to present the basis for granting immunity. Little did we know that they had already done that, and they were going back there to have that other conversation. So that's
Okay. Yeah, I mean, I know y'all didn't know the substance of it.
Exactly. That's pretty much it. So next Monday is going to be insane. If Melnick comes in and the judge allows him to pretty much testify that Miss Love and HYLTON are liars and misrepresented to the judge everything in the ex parte meeting. Everything else today was pretty tedious with the Woody shit. I'm so over all of that. That prior inconsistent statements and co-conspirator bullshit and the hours and hours of Woody snitching. Like, we've been getting a lot of members, so I appreciate all you guys. It's only 10 cents per day, and the other one's $8 a month, I believe, for the extra bonus video per week. Hit subscribe, like the video, follow me on Twitter and Instagram. Love you guys. Peace out.